Welcome to All Things Financial with Jack Driscoll. Each week, Jack takes on all things you thought were hard to understand about your finances and makes it fun, easy, but most of all interesting. From insurance to the best way to save your money and squeeze the most out of the dollars you put aside for your rainy day. And now, you have a friend in the money business. Here's your host, Jack Driscoll.
Welcome back again, everyone, to another edition of All Things Financial. I'm happy here to have a guest with us again today, Tammy Singleton English. I appreciate your coming back on the show.
Nice to see you.
Would you explain a little bit about yourself and where your firm is and
Sure.
history a little bit?
Sure. So I am an attorney and a CPA. My office is right near South Hills Village. I'm in the St. Clair building, which is on Route 19 at the intersection of Fort Couch Road. Our street address is 1725 Washington Road, Suite 301, Pittsburgh, PA 15241. And our phone number is 412-851-0529. And we also have a website, singletonenglishlaw.com.
How long have you been doing this, and what primarily is your practice about?
I have been a CPA since college, so that was way back.
3 years ago.
At least, yeah. So I was a CPA. I worked for one of the large accounting firms back in the days when there were 8 of them.
Okay.
Then I went to law school at Pitt and got my law degree and started practicing law in the estate planning field. I worked first for a very large law firm in Cleveland, then returned back to Pittsburgh, and I have worked for 2 large accounting firms, both one in the audit department and one in the tax department. And I worked for a large law firm in Cleveland and a large law firm in Pittsburgh. Then after I did all that, I started my own practice.
Okay.
So I've had my own practice now for about 20 years, and that's Singleton English Law Offices. So with the accounting degree and the law degree, I like to be able to combine the financial and the legal aspects of situations, which is how I ended up getting involved with the estate planning and probate and tax work. Those are the primary areas that we focus on.
So when we talk about those areas like probate, everybody says probate's horrible, everybody avoid probate. What does that mean? What is probate all about?
So probate is actually the process of administering an estate. And it varies from jurisdiction to jurisdiction. So the probate process in Pennsylvania is different from Ohio, is different from New York, is different from Florida. The general overview of probate is that the court oversees the administration of the estate to make sure that the executor is following the wishes of the decedent as they are set forth in that person's will, assuming that they had a will. And if they didn't have a will when they died, which is known as intestate, you die without a will. And then there are rules that each state provides that dictate how the estate will be distributed.
Okay, so we have someone, let's say they die accidentally, never thought about
Right.
death, never thought about it, never prepared, never gave it a thought, and then dies. Do they go through probate?
Yes.
Does their estate go through probate?
Yes.
What if they're married?
So if you die without a will, as I said before, that's called intestate, and that's when these state rules will take over. If you are married and have no children, then your surviving spouse inherits all of your assets. If you are married and you have either surviving children or surviving parents, then your spouse splits the estate with those individuals. So it would be the first $30,000 goes to the spouse, then the rest is split between the spouse and the children and the parents.
And the parents of the deceased?
The parents of the
spouse?
decedent, yes. Right.
So the spouse doesn't get everything?
The spouse doesn't get everything. Right.
Just because they didn't do a will, I guess?
Correct. So if you want your spouse to get everything, the solution is to write a will before you die.
Okay.
The other thing is that under the state intestacy statute, it doesn't matter if you're estranged from your children or estranged from your parents. If you die without a will, they're going to get a share of your estate.
Okay.
Whether you spoke to them within the past month or you haven't spoken to them in 30 years, the state statute doesn't care about that. And that's another reason why it's important for people to take the time to draft a will, because you can specify then who you want to inherit your assets and what they're to get and how much they get and when they get it.
Okay. So somebody decides from listening to this show or watching it, we'd better get a will.
Right.
What's involved with that? Is it expensive? Is it hard to do? Is it complicated? What's involved, and why don't people just do it?
I think the main reason why people do not get a will is the denial, or they don't want to deal with the potential death. Okay. And unfortunately, it happens to all of us at some point. And it's easier to have that conversation when you're healthy rather than waiting until there's a diagnosis of cancer or something, and then it becomes a much more difficult process. Okay. In terms of actually making the decision to get a will, you do not actually have to have a lawyer. You can write your own will. The downside to that is if you don't know what the rules are and you don't know how the law is going to interpret what you've written, you may not end up with what you think you're going to get. Because if you take a piece of paper and write out who gets everything, if it doesn't comply with state requirements, it's not going to be a valid writing. That's the first thing. And then some of the things that you dictate in there may not be legally enforceable. I see. So that's one of the risks if you decide you're going to just take this into your own hands. Okay. If you want to hire an attorney, you know, my experience with people is that people will call my office and we'll set up an appointment and they sit down with me and we talk about who are their potential beneficiaries, what their relationship is, what their assets are, and who they want to benefit upon their death and what they want people to have. And then I generally will draft a document, send it to them to review, and then if they want to change anything, then we change it and then it's signed, and then you don't have to think about it for a while. So then it's okay. It's not a one-time event, because the ideal situation is that you would review your will and your estate planning documents every 3 to 5 years. Okay. Circumstances change, the laws change, your family members could change, there could be deaths, births, marriages, divorces. You could win the lottery, so you're now looking at a bigger tax implication and different complications. It's better to have an old will than to not have a will at all, but it's better to have, the best is to have a more current one that reflects your current situation and your wishes. Okay.
But it's a simple process.
It's a simple process. It's a simple process. Okay. A lot of my clients come in and they're shocked at how easy it is. Okay. But I do the hard part. I know what questions to ask people. The hardest thing is for people to decide who they want to serve as executor and who they want to serve as a guardian if they have minor children. I see. And that's a question I cannot answer that for people. But if it's a husband and wife that have differences of opinion, that becomes the hardest issue for people, because they can't agree who the executor and who the guardian will be. But other than that, the actual process of writing a will is easy. It's just like you and I sitting down and talking, and I kind of talk them through it, ask the right questions, and then a couple weeks later it's finished. Okay.
And what considerations should most people have when they go through, decide to get a will, and then something happens to them? Does that mean they're going through this process that everybody talks about called probate? And what is that?
Right. Okay, so when you die, probate essentially is the process that controls the disposition of any assets that are controlled by your will. So out of the types of assets that people have, some are controlled by your will and some are not controlled by your will. For instance, life insurance and IRA accounts normally have a beneficiary designated. So those assets are not controlled by your will, therefore they are also not probate assets. I see. So if you have a $1 million life insurance policy and you designate your spouse followed by your children, when you die, that life insurance policy is not subject to probate. It's not involved in the process. The court doesn't have any oversight. The attorney that's managing the estate is not involved with it. It's strictly between the beneficiaries, which would be the spouse and the children in my example, and the life insurance company.
Okay.
So that's a non-probate asset, so that doesn't get taken into account. Jointly held accounts also are considered non-probate assets. So if husband and wife own a joint bank account and the wife dies, that bank account automatically becomes the sole property of the husband.
Okay.
Again, that does not require any court oversight. It does not involve the attorney. It's between the surviving husband and the bank to get that account re-registered into his individual name.
Okay.
So the probate process controls the assets that the person owned individually. So if I have an individual bank account or an individual stock portfolio or an investment in a mutual fund or a car, or I own a piece of real estate somewhere without anybody else's name attached to it, those are all probate assets. And what happens is once somebody dies, the first step really is that the family members need to all get together and plan the funeral and go through the grieving process and manage their emotional and financial family situation first. That's the first and most important part. Then they should make an appointment to see an attorney who specializes in this area to help them through the process, because there are a lot of steps, and if you miss a step, it may create a problem later. And people sometimes don't realize all the things that they have to do to probate an estate. There's one way that people can avoid probate when people talk about, I want to avoid probate. My neighbor said I have to avoid probate. My brother-in-law said I have to avoid probate, which would be to either have every single asset that you own be in joint name or a beneficiary designation, which also includes like a transfer on death account or a payable on death account. Or you can create a trust and transfer your assets into the trust, because now the trust owns your assets and your will does not dictate the disposition of those assets, and therefore you don't have probate.
Okay.
Honestly, in Pennsylvania, probate's not a cumbersome process to the average person. There are some states where it's very time-consuming, it's very expensive, and in those places, you do want to try to avoid probate. I used to work in Ohio, and Ohio's probate process is much more complicated than Pennsylvania's probate process. Every single thing has to be approved by the judge. So the executor and the attorney have very, very, very little authority to make transactions and essentially get things done, because you have to go to the court and ask for permission to be able to pay a bill or transfer an asset or make a disposition.
Really?
So it's a very complicated process in Ohio. And I don't know other states, because those are the two states that I've worked as an attorney. But in Pennsylvania, between the executor and the attorney, most things can be handled. There are very few things that require court intervention. At the end of the probate process, you have to get the court to approve everything that you've done. But that's kind of a one-time, you present the facts and explain what's been happening in the estate, and the court generally will approve what you've done.
Okay. That's good. What about time? Timing, like someone passes away, we read the will. You see sometimes on TV they show everybody sitting around reading the will. You get this, you get that, and you got cut out. And then here's everything. And does everybody get everything the next week? Or how does that work?
Well, first of all, the reading of the will that you see on TV and in movies very rarely happens in real life anymore. It may have happened back in the 1800s, but it doesn't happen very frequently now. Generally what happens is the attorney and the executor should be nominated in a person's will.
Which means the person making the will says,
I want
here's who I want
so-and-so.
to be in charge.
Right.
So, is that the person they like best or they like least?
Good question. The job of executor is not an honorary position. There's a lot of work. It can be very time consuming. I tell people that the best person to serve as executor is somebody who has time to spend working on this, because it takes a lot of time, and somebody who's detail oriented, because there are details upon details upon details. Somebody who's just a big picture person is not a good person to serve as executor, because that person doesn't want to be bothered with the details, and the details won't go away. They have to be dealt with. Now, if you don't have somebody that is the perfect executor, then you name who you think could be best. Oftentimes people will name their spouse or their children. It doesn't have to be that. It can be a friend, it can be a bank, it can be a sister-in-law, it can be your next door neighbor. It just seems like most people name their spouse and or their children. But really the more important thing is, will that person have the time to do all the jobs that position requires? And when I work with people who are serving as executor, I give them the option, because to do an estate administration, there might be 200 tasks. So out of the 200 tasks, there are about 10 or 15 that the lawyer has to do. There are probably 20 or so that the executor really needs to do. And all the ones in the middle can be done between the executor and the attorney. So I work with my executor and I'll say, do you want to do this, or do you want me to do this? Or do we want to split it somehow? Because some executors, I had an executor once who was a retired banker, and he was a fantastic executor because he was detail oriented, because he was a banker, and he had time because he was retired. So he did a lot of those in-between jobs because he had the wherewithal and the time to do it. I've had other executors who are working mothers with 3 children and 4 dogs and cats, and they want to do those 20 things that they have to do, and they want me to do everything else. So there's a whole range of how we work that out. But as to the reading of the will, so what generally happens, the executor and the attorney prepare a notice that is sent to all of the beneficiaries, and you are notified in writing, typically by mail, of what you are going to inherit from the estate. It's not generally done in person in a room where everybody sits down and you read the will. It's generally done in the mail by this written notice.
Does the notice show what everybody's receiving, or just what you're receiving typically?
The notice shows what that particular person is going to receive. Oftentimes we send a copy of the will so that because the will is public record. So you could go down and look at people's wills if you want to. There's it's not a private document. So oftentimes we'll send a copy of the will so everybody can see what everybody else is getting, but the notice only mentions specifically what that particular person is inheriting. And then the whole process of estate administration, if there are no problems, so that means no litigation, no fighting between the heirs, no lawsuits, no extraneous events happening, it is about 14 to 18 months.
Wow, and with no fighting.
With no fighting. The reason being that in Pennsylvania there's a creditor claims period, which is a 1-year period of time. So after the person dies, one of the jobs that the attorney or the executor performs is to notify the world by publishing that person's death in the newspaper. So you've seen death notices in the newspaper. There's a legal reason for that. It's not just to let people know somebody dies. There's a legal reason for that as well, which is that notice in the newspaper starts the creditor claims clock running. And from that date, there is 12 months for a creditor to make a claim against the estate.
Did that used to be 6 months? Always 12?
As far as I've ever known, it's been 12.
So now we're dealing with over a year.
And that's why it takes that long. And not to say that you can't inherit your assets. We can do advanced distributions before the estate is closed, but we will not close the estate and make all distributions, because if 11 months and 3 weeks into it, the executor gets a valid claim from a creditor for $50,000,
Yeah.
there better be money left to pay that claim, or the executor will pay it out of his or her own pocket.
Wow. So the executor's personally
On the hook.
responsible.
And which is another reason why I will not let my executor make a total distribution until that creditor claims period is completely expired.
Okay.
And now if it's an invalid claim where some lunatic person says, "Oh, I'm going to try to get money from this stranger," well, that's not enough. That's not what we're talking about. But if it's a valid claim, and a lot of times my clients feel that they know that their parent or their spouse didn't have any outstanding debt. And oftentimes that's the case. But every once in a while, that person made a loan or borrowed money and the family members didn't know about it, but the person that was on the other side of that transaction knows about it.
Really?
So if the decedent borrowed money from his business partner to pay a bill that the family didn't know about, well, the business partner is entitled to be repaid. And if that person makes a claim against the estate, that's a valid claim that has to be paid.
Wow. Okay.
So that's why generally it's over a year for the whole estate administration process, because you've got that 1 year creditor claims period, and then there are some final documents that have to be prepared and filed after that time has passed.
Okay.
So I'd usually tell people that it could be as much as a year and a half. And then if it's a little bit shorter, then that's a good thing. But it's not going to be within 2 weeks. And when people think, "Oh, Uncle Bill died and he gave me $5,000, well, you might get that $5,000 if the estate is large enough to be able to pay any bill or any other expenses that come through or claims that come through. You might get the $5,000. But if you are a beneficiary of half, say you're one of the 2 children, and you're going to get half of everything, again, you might get part of it in advance, but you won't get the whole thing. You won't get the whole amount until well after the 1 year. It might be 14, 15, 16 months.
Wow. Okay. Well, it looks like we're out of time. So what I'd like you to do is, again, refresh, in case anyone wants to get in touch with you, how people can do that before we have to sign off today.
Okay. So again, it's Singleton English Law Offices. Our address is 1725 Washington Road, Suite 301, Pittsburgh, PA 15241. And that is in the St. Clair building, which is the building right beside Walgreens at the intersection of Route 19 and Fort Couch Road by South Hills Village. Our phone number is 412-851-0529, and our website is singletonenglishlaw.com.
Appreciate it, Tammy. Thank you all for tuning in to another edition of All Things Financial, and I'll be back again next week.
Securities and investment advisory services offered through SagePoint Financial Inc., member FINRA SIPC, and registered investment advisor. Insurance services offered through Driscoll Insurance and Financial Services Inc., which is not affiliated with SagePoint Financial Inc.